by the three-judge bench today as they lifted the conservatory orders that were issued in Kerugoya. They were set aside, and that means Gachagua's case can continue till its logical conclusion. But there's a big but, and that's why on our top story we mentioned that we expect the swearing in of Professor Kithure Kindiki tomorrow, since those conservatory orders were lifted. But it's proper to get the feeling of the legal minds and the political minds, and that's why we're joined by a well-abled panel. Allow me to introduce our panelists joining us in studio. We're joined by Advocate Willis Otieno. It's a pleasure to have you with us. Karibu sana. Thank you for your time. Kathy Rongo also joins us. She's a political analyst. It's a pleasure to have you with us. Good evening.
Thank you very much.
Asante sana for your time. Dr. Duncan Ojwang needs no introduction. He's an advocate. Equally, we appreciate your time. Thank you for making time.
And definitely, we also expect Eric Komolo, an advocate and legal scholar, who should be joining us via Zoom. All right, straight to the conversation. Maybe I'll start with you, Willis. You know, conservatory orders have been lifted. Professor Kithure Kindiki will be sworn in tomorrow at KICC at 10 a.m. Does this upset Gachagua's court plan?
You know, they say, to whom the bell tolls. Tonight, the bell tolls for Rigathi Gachagua. And I do believe that his quest to reclaim that seat has come to an unfortunate and sudden end. Because once the conservatory orders that were in force have been lifted, and the court says that the matter can still proceed on to full hearing, what are they going to hear? No court is going to nullify the nomination of Kindiki at this particular stage to reinstate Gachagua, even if he has a legal case, a strong legal case. And look at that ruling. The court says that he has a prima facie case, and that the court has jurisdiction to hear the matter, and that this is a matter that ideally should be heard on its merits. So having established a prima facie case and having a certainty of jurisdiction to hear the matter, the logical thing for a court, as we know it, will be to preserve the substratum of the petition. And the argument that we cannot have the vacancy in the office of a deputy president, that same court has been sitting here for the last 2 weeks with that vacancy. They could have said we can't have a vacancy in the office of the deputy president, we are going to sit day and night and conclude this matter on the same day, so that vacancy will occur. But then you have the constitution itself, 149, article 149. It's very clear. You can actually have a vacancy for up to 74 days based on the calculations of days given in the Constitution. So this, to me, was Gachagua's day of reckoning. His past conduct has caught up with him. I will not even put it beyond my imagination that partly is uncalled for fight with the judiciary. Sometimes last year, when he said that he had a complaint against a particular judge and that he was going to file a complaint with the JSC in regard to a particular serving judicial officer, a very poor lady who all she has ever done is to dispense justice based on the facts and the law before her. So Gachagua went to court, in my view, as a very weak man. In the eyes of the court, he was not somebody who will be looked at favorably. But largely also impeachment is a political process, but we only demand, where is it? Despite Gachagua's many political sins, and I don't subscribe to his politics, he is entitled to the due process of the law. And this particular instance, Gachagua is being denied his due process of the law, as we know it as lawyers. As if you look at the conduct of the National Assembly, look at the substance of the allegations, the debate of the motion, the conduct of the Senate in conducting that impeachment proceedings, now even the judiciary, now even see all of a sudden government printers, the most effective, most efficient government department in the history of this nation. We are getting Gazette notices being churned out every 1 minute. It's like the government printer is sitting somewhere in State House to churn out Gazette notices in favor of for start this work. Because there is no emergency to speak of that you can say, if they are not doing this thing they're doing with so much speed and haste, there is no emergency. The heavens will not fall. But unfortunately for Gachagua, it seems the heavens have fallen on him, and the political system and the legal system have denied him that opportunity. At least so that we can hear him and interrogate him. I would have actually wished to see Gachagua being cross-examined on his conduct and on his performance. Okay. They denied us that opportunity. They denied him that opportunity.
Okay. All right. So, Kathy, as you come in, they say it's not over until the fat lady sings. So, politically, has the fat lady sung in regards to Rigathi Gachagua's political lifeline from where you sit?
Oh, yes. I mean, when you look at the political process, and the political process is actually what happened in the National Assembly, in the Senate, and it definitely, again, led to the president, naming Professor Abraham Kindiki as the incoming deputy president. Yes, we are at that stage. I believe chances of survival for the former deputy president are really minimal, or they are not there at all, going by what has happened. And look at what happened in National Assembly and also at the Senate. It's a game of numbers. It's a game of numbers. And we saw, again, what happened during the public participation. During the public participation, over 75% of the people who participated in the public participation actually voted for his impeachment, or they agreed for him to be impeached. When you go to the National Assembly, it was actually over 80%. When you go to the National Assembly, the same thing. So really, I think the best thing for the former deputy president right now is just to throw in the towel and move to something else.
Dr. Ojang, coming to you, I mean, looking at the matter and the process and what we saw today, the appeal court and what they say it will be pushed to next week. Many are asking, so then what exactly is he fighting for? Considering come next week, that position will already be filled.
That's a very good point, but let me start by congratulating Professor Kindiki. And I think Willis might even find this to be a point to agree that we believe lawyers can do some of this job with much more integrity. Think like a lawyer, forces lawyer to think of issues and the law at the back of their mind. And I think, again, congratulate Kenya that this is a new ground. They have broken a new ground of peaceful transition of power. It is actually becoming our custom or ritual that we have a way of peacefully transitioning, unlike other countries around. But I think to answer your question, whenever legal rights collide, at least as much as many, both sides disagreed almost on everything, they agreed that court is the right place to go. And the law is the right place to look into for resolution of those conflicts. I think that the court, of course, everyone saw the ruling, weighing the public interest, saying the public interest, which is about the transition and the office being occupied so that those roles are implemented, vis-a-vis the roles that Wakili Lewis have articulated very well, which is the rights, the individual rights, be it procedural or all that. And so they put it on a scale and said, you know what? If it is compensation, if there is something we don't think that this is now academic exercise, but we cannot stand on the way of stopping a constitutional process while we are also a creature of the Constitution. In my view, I was even more optimistic or looking forward to the ruling on jurisdiction. And I think for those who listen, the issue of Madison versus Marbury came in. A very interesting case. The Supreme Court of the US had no jurisdiction, but they were able to weave themselves in, give Congress what they wanted, give the executive what they wanted, and then say, in future, if such cases come, guess where is the stop place? Come to court. And I can see, for those who felt the court did not have jurisdiction on impeachment, that the court was able to weave themselves in, and so they are beneficiary. They're saying any dispute is justiciable when it comes to us. Now, why still go on? I think the reason why it is important, of course, for our jurisprudence, of course, courts have an avenue of even clearing the former deputy president Rigathi Gachagua to be able to run next time and not to wait for the 8 years. To say that because some of your there is genuine cases, some of the processes were skipped, therefore we are finding that impeachment might not have granted you the pure rights, and therefore we find that you can still run. I feel that is a real issue why he's running. Finally, I think I want to congratulate the lawyers because I teach a course called Law and Rhetorics. And there was a lot of rhetorics here. I tell my students that whether the case is about a chicken thief, you cannot submit the case without invoking higher principle like, Your Honor, for the sake of justice. And so we saw a lot of rhetorics there, but those are judges, they were able to look at it. And I see a clear path that we have turned the page, and here come a Deputy President Kindiki. So the case might have slowed down and maybe halt, as Louis is saying, but I think the story continues, and the story is the political part.
Interesting. Let's just bring into the conversation Eric Komolo, who's joining us virtually. Komolo, it's great to have you with us. Perhaps let's indulge your take on the matters that were raised and whether they're justiciable. Because going by the verdict and looking at the doctrine of separation of powers, to what extent can the court oversight an impeachment process? That issue came up. Give us your take on it.
Well, thank you very much, and pass my greetings to my good friends, Dr. Joan, and my classmate Willis, and the lady there. I did follow the delivery of the ruling, and it's obvious that the High Court did determine first that they have jurisdiction, 2, that the issues are justiciable, and 3, that there is overriding public interest. And I think that is really the real issue for tonight. But going back to the question of justiciability, I think what they identified is that the petitioners, and it is important to remember that the petitioners are not necessarily the former deputy president himself, and anyone under the Constitution has right to question processes. So they did determine that the issues raised in those petitions raise fundamental constitutional issues or questions that they ought to determine. Now, they have not framed. At the end of the day, once they start what is called conferencing, next week, then they will determine the issues that are ripe for determination. We don't know them. But at the very least, they did tell us that it raises, the competitions do raise things that should be determined and that the court has jurisdiction. Obviously, in a situation like this, not everyone will be happy. It is obvious that there are a section of Kenya who thought that they should have upheld the conservatory orders, and it's also obvious that there are sections that thought that the conservatory order should be lifted. But this is pure question of either jurisprudence or discretion. Discretion simply means that once you are a judge in a situation like the 3 judges did find themselves, then you exercise your conscience and discretion to be able to either lift or retain the conservatory orders. And in this case, they have decided to lift. From a scholarly perspective, my bigger concern is consistency in terms of judicial jurisprudence around conservative orders in Kenya. And I spent a lot of time listening to Justice Murima justify why they lifted, and he really came up with a very reasoned argument about vacancy or lack of it in the office of deputy president. Now, the alternative argument could also have been true, which is why judges have a right to be right or wrong. But in this case, they have decided to lift. And from a scholarly perspective, as I just said, the bigger question would be then what is the jurisprudence that is being established? Remember, as I speak to you, the governor of Meru is in office courtesy of conservatory orders. And there have been a lot of litigation around deputy governors and governors that are in office one way or the other or that have succeeded one way or the other because of intervention of the High Court. I recognize that the office of president and the office of deputy president are in many ways very different. They are sui generis in law, and they are only those are the only two offices that clearly the Constitution stipulates procedure for removal, including impeachment or through medical process and all that. So it is unique for all of us, and I can see why all of us are struggling to understand what has happened. What is clear to me is that Professor Kindiki will be sworn in tomorrow.
Okay.
And the High Court will have opportunity next week to interrogate substantive issues that have been raised in the petitions. What I'm not sure about is what the High Court will decide, since once we have Professor Kindiki, then go give or take, it's almost impossible to then remove him. And I will later in this conversation give you my position on what I think should be constitutional amendments around handling impeachment, because I suspect now that this thing is slightly beyond the ordinary judicial process.
Okay, Komolo, thanks for that clarification and giving us your input. That's a conversation we're set to continue with at the top of the hour. Mind you, this is just the tip of the iceberg. We've barely scratched the surface. A lot to talk about, so little time. So allow us to take that short break. We'll still retain the